Registry Matters is an independent production. The opinions and ideas here are that of the host and do not reflect the opinions of any other organization. If you have problems with these thoughts, FYP.
Recording live from FYP Studios East and West, transmitting across the internet, this is episode 307, recorded on June 15th. This is Registry Matters. Good evening, Larry. How are you, sir?
Doing awesome. Glad to be with you again. I don't know how much longer this is going to last, but I'm glad to be with you this episode.
Are you anticipating something ending you sooner than, soon, I guess?
Well, with all the airplanes that are falling out of the skies and doors falling off of them and catching on fire and stuff, I would say that since I'm flying this week, there could be a good possibility.
Well, I think then all you really have to worry about is don't get on a Boeing, 737 MAX or whatever it is?
It's hard to fly Southwest Airlines without flying a Boeing because that's the only planes they fly, 737.
Oh. But so this one I read today was in Honolulu or whatever. They were hopping across some islands and the co-pilot decided that they needed to drop 16,000 feet.
I don't even know about that one.
Ooh. Some instruments or something told him that he needed to dive, and he pushed the stick, and they went from 16,000 to 400 feet. Is what I've read. I was like, ooh, those people were, they were probably very antsy, I guess would be a way to put it.
I bet the people on the plane thought it was funny.
I'm sure they thought it was hilarious. They were like, whee, with their hands up in the air like they'd just gone over the top of a roller coaster. Well, Chance, how are you, sir?
Wonderful and sunny California. Beautiful.
Of course. Every day in California is sunny and beautiful, I'm sure.
Sunshine.
And you've lived there for how long?
All my life.
All of it?
Well, no, I've gone other places and stayed short, but for the most of my life, I've been here.
Fantastic. Wow. Okay. Well, make sure you go over and show support for the podcast by hitting like and subscribe. Oh, I do want to tell everybody that if you didn't notice last week, I released individual little segments. It took me a crap ton of time. So please show some level of appreciation for it by going and thumbing and liking and, watch it for a few minutes so to get some numbers up there. Man, did it take a long time to go make blog posts for everything and make videos for everything. But so anyway, we do truly appreciate it. And I'll let y'all know later. We did get a new patron this week. And so anywho, what are we doing this week, Larry?
Well, we have an adverse decision from the United States District Court for the Middle District of Louisiana. And we have some articles. One of them's from California. And we have the California Corner with Chance Oberstein. And we're going to try to get this episode done in 20 minutes.
Okay, wow. Cool. I will talk incredibly fast then. But before we get going, you have something you want to tell us, and that I think you think that I'm going to think it's funny, but I, as usual, nothing you say, Larry, has me laughing very often. So go for it.
Okay. Well, last week, I was looking over the transcript, and I saw what I thought was careless mistakes because remember that name, that woman that made the false accusations that you were having trouble pronouncing?
Yes.
Well, I thought that what I had in the show outline was correct. So I sent a polite email to the transcriptionist, and I said, we've got to make sure we get this stuff right because it's important not to misname a person. And he said something to the effect of, I agree, and that's precisely what I did. He said I checked it. I checked the court filings in Bucks County, Pennsylvania, and he said the spelling that is in the transcript that he provided, he said that is correct. Well, by the time that exchange went down, I had already restored it back to what we had originally, published a transcript, sent it for distribution, and I think it was already in the mail. So you have 900 copies of the transcript in transit that has it misspelled. And I'm telling him how important it is for it to be spelled correctly. And he went the extra mile doing the research to make sure it was correct. And then I made it incorrect. And can you please admit that that's funny?
Okay. Larry, I have told you on the phone every day for about the last 2 months. I am not going to admit that something's funny, but that's funny. I like that. So he was telling you, shut your pie hole. I did this right. And you're like, no, you didn't. You didn't do it right. And I'm going to send it out. Yes, that's funny. If it's on you, Larry, it's funny.
That's what I told Chance. I said, this one's going to be funny because it's on me. But what's even funnier is that I adopted your doctrine of AI is always right. So I was using the YouTube translation provided by Google, which Google could never do anything wrong. And rather than using the TV station's closed captions, and I used the AI, and that was where the problem. If I'd have just left it the way it was, but I just knew I was right, and he was actually right, and that shows the diligence that he's going through to take the time to make sure that names are correct. And then I'm saying, now we got to make sure these names are correct. And he said, yeah, I agree. That's what I did.
And I'm sure you did it in a very polite tone, very friendly, cordial.
Yeah, I did indeed. Yes, because he's doing a great job for us.
Now, just for the record, I have never said AI is always right.
Well, not it is always right, but it's the greatest thing since bread toasters and slicers of bread.
I believe that that's true. You have no idea how much it has radically altered my day job.
So,
all right. Well, let's see. Before we get going, what is your prediction on in the terms of the surgical castration bill sitting on Governor Jeff Landry's desk in Louisiana? Do you think he's going to veto it?
Not very likely.
I see. And all right, so can't the governor / president don't they have the power, the veto power? Isn't that one of their almost like top line charters?
It is. Yes, he does possess that power to veto.
So why wouldn't he say this is some dumb shit and veto it?
Well, you have to look at the reasons vetoes happen and why they don't happen. And I did a little bit of research on this Governor Jeff Landry. He's been Attorney General. He's law enforcement oriented.
There you go.
And he's anti-abortion. He signed one of the most strict abortion bills in the country. But he is faced with a very difficult choice. Even if he were to be like Mike Huckabee, the former governor of Arkansas, and he had any consternation, which I doubt he does, but if he did, he's got something that passed either unanimously or near, or completely unanimously or near unanimously. So he would have to go to the legislature and provide them a message and reason for his veto. And had he not been expressing any concern about the legislation throughout the process, his legislative support would feel blindsided because they would have been sensitive to the governor had he had any concerns about this legislation, because he's of the same party. The legislature's like veto proof to begin with, and he would have to have communicated to them that he had angst about this bill, and apparently that was not done. I was not able to find any concerns expressed by the executive branch. So therefore, the likelihood of him vetoing this is so small. But yes, he does have the power. But I would anticipate an override. I would think that leadership would be irritated that they hadn't heard any concerns, and they would feel like this would be potentially used against them in a primary campaign the next time they're facing the voters. And I don't think they would think it's amusing, and I think they would override it. That's what would happen.
Larry, I can't resist. So first of all, I'll let you fill in the blanks. Like this individual, where do they live? So this is Brian in Louisiana. He says snowballs in hell have a better chance than a Landry veto. That's the first comment.
I tend to agree with him on that. Yes.
And then the second one is also a person in Louisiana. He says, meanwhile, our glorious swampland leader has also signed a bill that allows 17-year-olds to be charged with crimes as adults and another that doesn't require employers to give juvenile employees a lunch break.
Please admit that that's funny.
You should have had your snacks before you got to work.
Never mind the fact that you're still growing as a teenager. Never mind all that. That is funny.
God, where the hell do we live again? Jesus Christ. All right. Can we go on to this main event thing then?
I guess so, but I hope I'm wrong, but I don't see a veto being on the horizon. I think he will sign this. And in fact, I would predict he would sign it with fanfare and have press and announce how that he's holding people accountable and protecting the children. That's what I would anticipate.
Of course. All right. Well, you put in this case from the U.S. District Court of the Middle District of Louisiana. The name of the case is Archie Williams, the City of Baton Rouge et al. What does et al? And that's E-T-A-L. So I'll just say et al. What does that mean?
Well, it means rather than naming all the parties, it just means and others. It's one of those Latin terms. I think I've got it right, but Chance can correct me if I'm not right. But that's what I recall.
Correct.
They use that in scientific papers too, by the way. So they'll name one publisher or whatever researcher, and then they say et al. Like that.
Yeah. It should be versus. Let me put that in here for the transcript. So
I'm sure he would correct that and send you nasty grams about it too. He's not in here, so we can talk bad about him. And what's this case about?
Well, the plaintiff is named Archie Williams, was wrongly convicted of rape in 1985, and he spent 35 years in prison for a crime he did not commit.
Now, how do you know he did not commit it?
Well, I'm going by what the evidence has shown in the decades since he was convicted.
Oh, okay. Well, let me set it up then. So on December 9th of 1982, a white woman was raped and stabbed multiple times in her Baton Rouge residence which she shared with her husband and 2 children. The assailant was described as, of course, a black man who acted alone. The man forcibly entered the house and took the woman to a second-story bedroom. The woman recognized him immediately as someone who had come to her back door around a month earlier saying he was lost. She was face-to-face with him multiple times during the incident. During the assault, the woman noticed a 3-inch long scar on the attacker's right arm. Following the assault, the victim was treated at Baton Rouge General Hospital. At the hospital, police officers arrived and worked the victim to create a picture of the assailant. This doesn't sound good at all.
No, it's not good. And in this case, I don't believe this is going to be anything paralleling last week of false accusations. I believe this woman was viciously raped, and this is legit. But while still in the hospital, officers began bringing photo lineups for the victim to look at. Officers continued bringing lineups to the victim when she was released from the hospital. In one of those lineups, the victim identified the individual who she thought strongly resembled the man who had attacked her. But the man in the photo had different hair. The police brought a different photo, this time in profile, but the hair of the man in the photo was still not right. Finally, officers brought her a lineup, and she jumped out of the chair screaming, "That's the one." I'd like to ask Chance, Mr. Oberstein, who's been doing this for 34 years, more familiar with lineups than I am, if he sees anything wrong with the investigation up to that particular point.
Heck yes. But before I respond, I'd like to note that the woman testified at the trial. She related that after seeing the photo, and she said it was the best feeling in the world to know that there wasn't any doubt left in her mind. She did not hesitate in any fashion when identifying the man. 2 days later, the woman went to a physical lineup where she saw him instantly. The man she identified was plaintiff Archie Williams, and she identified him in open court at trial. Following her open court identification, plaintiff stood before the jury to reveal a scar on his right arm. The victim identified the scar as the one she saw on the arm of the man who raped her. She seemed certain nonetheless.
What do you see wrong with the process up to that point? I mean, I've never witnessed a lineup, so I know I've had seminars, I've attended CLEs on how to properly do them, but did the police follow reasonable protocols up to this point?
It looks like it was. Well, I want to interject here for just a second. It looks like they used a hybrid protocol that was highly suggestive. How's that?
I've heard a lot of podcasts talking about this, that the people doing the lineup need to not be the police officers that are investigating. That way they have no sense of how to influence the witness on, are you sure it's not the guy behind door number 4? Are you sure that's not the guy? They have to be completely removed from it, so it's like a double-blind study that scientists would use.
So, well, in this particular case, lineups are always problematic because the police wouldn't bring someone that wasn't a suspect. I mean, they're generally not going to put the bank executives and the city councilors and stuff like that in the lineup, and
Right.
they're probably not going to bring those type of, not going to bring a picture of Donald Trump or Joe Biden. So when they're giving these photo arrays, Chance, what do we have to be on the lookout for as a general proposition when a person is being either provided a mugshot book or if they're asked to identify in a lineup? What are the things that stand out that we should be on guard against?
Well, it's using the same photo over and over with a different mixture of people so that it suggests that that's the one. That's the main thing. And that's what often happens. You show a person 6 packs of photos. One person is consistent, all the rest are inconsistent. Then you show them a single picture and then another picture, and before you know it, they've identified the person who's consistent in the lineup and in the picture. That's the suggestive part of it. And so then they're married to this identification and believe wholeheartedly and sincerely that that's the one.
Well, she did seem certain, and the jury deemed her credible. At least it would seem so, since they convicted Mr. Williams. Williams was convicted April 21st, 1983, and sentenced to 30 years for aggravated burglary, 50 years for attempted murder, and life in prison for aggravated rape. Yet no physical evidence connected him to the crimes. For 36 years, Williams has maintained his innocence. In 2019, he was released from prison when latent fingerprint evidence recovered at the crime scene, examined using a fingerprint database created in 2014, and a different individual was identified as the attacker. Now, Andy, I know you're not going to admit this, but this is funny. 35 years later, after languishing in prison, they figure out.
Not funny.
Okay, if you say so.
I'm assuming that Mr. Williams filed this action after his release?
Correct. He got released in 2019. On March 17, 2020, Williams filed the lawsuit against the city of Baton Rouge and numerous officials for alleged misconduct in the investigation and the prosecution of his criminal case for which he was convicted. Specifically relevant here, Williams alleged 14th Amendment violations under 42 U.S.C. 1983, which is the civil rights mechanism to seek redress, against defendants Lane and Gaidry for failure to disclose exculpatory crime scene evidence, fabrication of crime scene evidence, and conducting a reckless investigation, and against defendant Miller for fabrication of whatever that word is, evidence.
Serological evidence? What is serological evidence? What is that?
I have no idea. That's why we have a lawyer here.
I bet you.
I'm not sure that's a legal term, but it's.
Oh, okay. It's
I'd have to look that up.
Serological is testing the blood type to determine if you previously had the virus and may have developed antibodies.
So
it's a medical term.
And failure to disclose exculpatory serological evidence, as well as state law claims for malicious prosecution, spoliation of evidence, intentional infliction of emotional distress, and negligence against all defendants. So he threw the kitchen sink up there.
But you say you don't like the kitchen sink. This all sounds totally legit of what he would do. Don't you think?
It does.
All right. Well, here it comes, though. Williams moved, for summary judgment on his claims against the defendant Lane, and the forensic defendants moved for summary judgment on plaintiff's claims, asserting qualified immunity. Both motions were opposed, in part. The plaintiff failed to respond to defendant Guidry's assertion of qualified immunity. Why would he have failed to respond?
Yeah. I wish I knew. It's not really my wheelhouse, but it seems he would have to get over that hurdle in order to succeed.
Do you think that we can go over the summary judgment, the standard for summary judgment then?
We can, yes. We'll go directly from the court opinion, yes.
All right.
So the summary judgment standard is well set. To prevail, defendants must show, meaning that to prevail, defendants must show that there is no genuine dispute as to any material fact, and they're entitled to a judgment as a matter of law, and that's Federal Rules of Civil Procedure 56A. In making this assessment, the court must view all evidence and make all reasonable inferences in the light most favorable to the plaintiff, the non-moving party. Even so, under federal and local rules, plaintiff must counter with evidence to support his claims. A non-movement movement will not avoid summary judgment by presenting speculation, improbable inferences, or unsubstantiated assertions. And that's Jones versus United States, 936 Federal 3rd, 318, 5th Circuit from 2019. That's the precedent that they're using to guide them, the trial judge here.
And then Williams alleged that Lane suppressed a crime scene photograph of a bloody palm print in violation of his 14th Amendment right to due process. In Brady versus Maryland, the Supreme Court held that suppression by the prosecution of evidence favorable to an accused violates due process where the evidence is material either to guilt or to punishment, irrespective of the good faith or bad faith of the prosecution. This is well-settled law, is it not?
Oh, yes, it is. It's the prosecutor's duty to provide favorable evidence, and that includes impeachment evidence and exculpatory evidence, and that's United States versus Bagley. You can find that at 473 U.S. 667, 676, and it's a 1985 case. The prosecutor's duty to disclose evidence includes both evidence in its own possession and any other favorable evidence known to others acting on the government's behalf in the case. And you can find that in Kyles versus Whitley. That's at 514 U.S. 419 at page 437. That's a 1995 case, by the way. And the duty to disclose such evidence is applicable even though there has not been a request by the accused. It has to happen automatically.
So what is required to prevail on a Brady claim?
Well, to prevail on a Brady claim, a petitioner must show 1, the prosecutor suppressed the evidence, 2, the evidence is favorable to the defense, and 3, the evidence is material to guilt or punishment. And I'm taking that from Miller v. Dretke, which is 431 F. 3rd, 241 at page 245. And that's a Fifth Circuit case that was settled in 2005. And that is citing Brady at 373 U.S. at page 87. Evidence is material only if there is a reasonable probability that, had the evidence been disclosed to the defense, the result of the proceeding would have been different. A reasonable probability is a probability sufficient to undermine the confidence in the outcome. And that's Bagley, 473 U.S. at page 682.
The order states, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, or whether after discounting the inculpatory evidence in light of the undisclosed evidence, there would not have been enough left to convict. Would, Chance, can you seriously, dumb that down? That's a lot of weird words and lawyer double speak and twisted back around. Can you dumb that down for me?
Well, let me give it a shot. I mean, to succeed on a Brady claim, a defendant must show that the favorable evidence could reasonably be taken out to put the whole case in a different light as to undermine the confidence in the verdict. In other words, that the verdict wasn't correct. And that's Kyles v. Whitley. That's 514 U.S. 419 at 435. The Supreme Court held in Kyles, that Kyles was entitled to a new trial because the cumulative effect of the suppressed evidence raised a reasonable probability that the jury would have reached a different result. And I think that's where the rubber meets the road in Brady.
But then how did the jury convict him?
Well, because they agreed on the
right? Sure. They all said guilty, right?
So, but because it was made clear to the jury that no fingerprint evidence, including prints in the blood, connected him to the crime. In opening arguments, the prosecutor acknowledged that, quote, none of the fingerprints taken from the scene matched the defendant, and admitted that there were 2 fingerprints taken from the scene that didn't match anybody. Likewise, defense counsel in his opening statement asked the jury to pay close attention to those fingerprints because none of those fingerprints are plaintiff's. None. At closing argument, defense counsel referred repeatedly to the fingerprints on the blood that did not belong to the plaintiff, Mr. Williams. Williams' conviction appears to have been based entirely on the tragically mistaken testimony of the victim herself. because the evidence shows that the jury knew the prints in the blood did not connect the dots to Mr. Williams, but they convicted him anyway. So that has to mean that they trusted her eyewitness account. And we've learned in the decades since then that eyewitness testimony is not all that reliable.
Not even close. She had a super traumatic experience, and for right or wrong, it was someone of a different ethnicity than her. And then so she had encountered the dude prior, and she put the two pieces together because they all look alike. And I'm not saying that, but that's what a lot of people would then say. This is so maddening. If I was on that jury, there's no freaking way possible that I would have found that dude guilty if all of that stuff was not matching up. The eyewitness testimony would corroborate the physical evidence. It wouldn't be the only thing required to knock the guy out.
But
All
you're saying that in 2024. What would you have said in 1983 when we had such limited knowledge of forensics and we didn't rely heavily on forensics back then? Do you think you would have said, with an eyewitness sitting there in 1983, he done it? And plus that scar being on, what would be the chance of a person would have a scar? Do you think you would have had the same attitude in 1983 that you have now?
I can only speak to that. I sat on jury in 2003, something like that. And I realized that that's still 20 something years difference. But we had the eyewitness testimony of the DEA guy. And she said that he took pictures of me and used those for extortion so that I would be an informant, whatever it was all that was going on. And we said, great, we believe you, but there's not a picture. So if you have the picture, then we can go along and say that the guy did it. But we had to say that he didn't do it because there was no physical evidence.
So,
But
well,
let's continue.
I would love to believe that racism didn't play a part in it. I hold those idealistic beliefs in our system when people raise their hand and say that they're going to administer justice without regard to that. When you lose that faith that people will take their oath of a juror, and I've made that oath. I've pledged that oath myself 2.5 years ago on the grand jury. I took it seriously. I like to believe that most people do take it seriously, but maybe they didn't.
Not in Louisiana, and still not today, man. Come on. Not Louisiana. Well, let's go into defendant Guidry's claim of qualified immunity. Williams alleged that Guidry should have performed an exclusion analysis on S12, the bloody fingerprint. He failed to contest Guidry's assertion of qualified immunity. How did the court resolve that particular aspect?
Well, not very favorably. The court stated, quote, a party waives an issue by failing to brief it. They cited United States versus Martinez, 263 Federal 3rd at 436, Fifth Circuit. Moreover, local rules require that parties support their arguments with a concise statement of reasons and citations of authorities, and that's Middle District of Louisiana, Local Rule 7D. And this court has repeatedly admonished that it will not speculate on arguments that have not been advanced or attempt to develop arguments on a party's behalf. Remember, they're supposed to be neutral, judges are. For this reason, Guidry is entitled to qualified immunity. So he abandoned the argument by failing to brief it. That's the way I read it. I don't know if Chance reads it differently, but I see that he abandoned the claim by not briefing it.
Chance?
Now, I agree with that. That's one of the things I think I mentioned before was if it's, that's a hurdle I think you've got to address. And, because it wasn't addressed, shouldn't be a total disaster. It shouldn't be a miscarriage of justice, but apparently here it is.
So what's next for Mr. Williams?
Well, he's got a couple of options. He can look for a new vehicle, or he can file an appeal to the Fifth Circuit, where this would go. But appealing this 1983 claim, these processes are largely well-defined in terms of what he would be appealing. I would expect limited or no traction if he were to appeal in the Fifth Circuit. So he has to find another vehicle and see if there's a recovery mechanism that exists, or he's got to convince the Louisiana legislature to change the law. Now, I know that Governor Landry, being a former prosecutor, And I know that all those conservatives that run the legislature, I know in my heart that they would want a miscarriage of justice to be compensated. And I know that they would quickly pass legislation immediately if they were asked to do so. Do you agree with that, Chance?
No.
You don't
I
agree
don't
with
think
that?
so.
You don't agree, would you agree with the part that he's got to find another vehicle or he's doomed?
Yeah, I think so. Yes.
So,
And just to reiterate, 1983, that's not the year. That is a civil rights claim?
yes, it's a section of U.S. code
Okay.
that allows you to seek redress, but it's very limited in terms of you have to jump through a lot of hurdles to show that the right that it was violated was clearly established, that it was deliberate, not a good faith mistake, and it's really hard to prevail on a 1983 action. But people do prevail.
And so the guy spends 36, is that what it was? 36 years in prison? And no one can see that his civil rights were violated?
Well, no, they can see that they were violated, but the vehicle he's using doesn't permit him to recover because these people are immune. And he waived immunity for the one that might have had some liability because he didn't brief it. It sounds like some bad lawyering, but I don't want to say it's bad lawyering because we've got a lawyer on the panel, and it may be bad lawyering, and there may be some strategic reason that he made that decision to abandon, but I can't imagine what that reason would have been.
Yeah, I can't either.
Does this then mean that they open the doors, let it out, and say, sorry, and there's nothing for him? There's no monetary, I'm sorry, 36 years are gone. Sorry, sucks to be you.
Well, Louisiana could have its own compensation scheme for improper incarceration, and some states do, and you would file the claim like it might be in a state might have it $50,000 a year or some arbitrary number for years of wrongful incarceration. But this one is going to be a little bit dicier because I would say there was no if I were sitting as a judicial officer, I would not see malicious misconduct here. We've got to look at this through the technology that existed at the time. We can't look at it through today's technology. So we've got to pretend we got to set up a trial in 1983, and we've got to look at the type of evidence that would have been available in a trial in 1983. And when we look at what evidence would have been available, they would have only had the evidence that they looked at. They would have not, if there was no fingerprint that matched anybody, then all they would have had was her evidence, her testimony. What were they supposed to do? Say, well, we're going to dismiss the charges because we don't have a fingerprint match. They would not do that. So I don't think there's anything malicious or willful about this. I believe that they thought that they had the right guy.
I cannot imagine, Larry, that Louisiana in 1983 would have a white victim and a black defendant, and that they say, "Oh no, he didn't do it." Louisiana is, I'm gonna catch hell for this, is one of the most racist states today, and it has not gotten better than what it was.
Well, I would say there are plenty of racists in Louisiana and Alabama and places like that, but if you believe that every prosecution that took place in 1983 was devoid of any consideration for the facts as we would have understood those facts in 1983 were very compelling at the time. You make the mistake of wanting to look at it through the evidence we have today. We have forensics today that have identified something they could not examine to a conclusory standard in 1983, and they've concluded that he was not the person. But in 1983, they thought he was the person because he had the scar, he had the eyewitness identification, and so it was a compelling case at that time.
Very well. California Corner, Chance, are you ready?
I am ready.
Are you a first-time listener of Registry Matters? Well, then make us a part of your daily routine and subscribe today. Just search for Registry Matters through your favorite podcast app. Hit the subscribe button and you're off to the races. You can now enjoy hours of sarcasm and snark from Andy and Larry on a weekly basis. Oh, and there's some excellent information thrown in there too. Subscribing also encourages others of you people to get on the bandwagon and become regular Registry Matters listeners. So what are you waiting for? Subscribe to Registry Matters right now. Help us keep fighting and continue to say FYP.
Very well. So we're going to return over to California Corner significantly earlier than we normally do. And this is the part of the podcast where we delve into intricacies of California law. Today we have a compelling subject lined up. We're going to discuss a legal argument concerning the implications of the tiered registry law for PFRs. We'll explore legislative intent, empirical evidence, and the broader implications for public safety and evidence-based practices in the criminal justice system. And of course, joining me today, I'm going to skip all that. So set it up, Chance?
Oh, yeah. Okay. It's all about effectively arguing for removal if your petition should go to hearing.
And so to dive right in, the argument we're discussing centers on a petitioner's registration requirement arising from a single conviction under Penal Code Section 288A. He has no other criminal history and has been assigned to Tier 2 under tiered registry law, which imposes a 20-year mandatory minimum registration period. Can you give us a brief overview of the key points of this legal argument?
Certainly. The argument focuses on two main points. First, it highlights the legislative intent behind the tiered registry law to remove low-risk offenders from the registry and concentrate resources on high-risk offenders. Secondly, it asserts that a petition to terminate the registration requirement cannot be denied without significant evidence demonstrating a risk of reoffense.
And so the first point, the argument states that the tiered registry law confirms the legislature's desire to remove low-risk offenders from the registry. What is the legal and empirical basis for this argument?
That's a good question. The tiered registry law was influenced by recommendations from the California Sex Offender Management Board, which we affectionately call KSOM. KSOM's research indicates that PFRs differ significantly in their risk to reoffend, and that this risk decreases over time if the offender remains offense-free. And by the way, so does Carl Hansen. So it's an empirically based assumption. The law aims to use, risk assessment tools to classify offenders into different risk levels, allowing law enforcement to focus on high-risk individuals who pose a greater threat to community safety.
Well, the argument also references People v. Smythe, unless they pronounce that Smith, to support this point. How does this case align with the argument regarding legislative intent and public safety?
Well, yeah, the argument does use People v. Smythe, and it's a 2024 case, and which can be found at 99 Cal App 5th 22, which emphasizes SB 384's legislative intent to prioritize public safety by efficiently allocating law enforcement resources. The case highlights that maintaining low-risk offenders on the registry consumes significant resources, which could be better utilized monitoring high-risk offenders. This aligns with the legislator's goal of enhancing community safety by removing low-risk individuals from the registry.
The argument also claims that requiring low-risk offenders to register for life decreases public safety. Now, who would say that that this supports that premise?
Well, obviously, an overloaded registry dilutes the effectiveness of law enforcement. That's who. When officers are tied up with paperwork for low-risk offenders, they have less time to monitor high-risk individuals. So, additionally, the public is overwhelmed by the sheer number of registered offenders, making it difficult to distinguish between those who are truly dangerous and those who pose little or no risk.
Is it okay if we move over to the second point, Chance?
Sure.
All right. The argument asserts that a petition to terminate the registration requirement cannot be denied without a significant evidentiary showing of reoffense risk. Would you be so kind to elaborate on what the legal standards and the kind of evidence that is required to support that?
Sure. Penal Code Section 290.5A3 specifies that if the district attorney objects to a petition for termination from the registry, they must present evidence showing the continued registration significantly enhances community safety. This means providing, reliable, material, and relevant evidence that the petitioner is likely to reoffend. Now, the Court of Appeal in People v. Ty which we have discussed in previous episodes, clarified that the prosecution bears the burden of proving the petitioner's current risk of reoffense.
Well, again, how does this requirement align with legislative intent behind tiered registry law? Because I could make the argument that registering people doesn't cost a dime. You could register a person and tell them to go off and have a good life, and you never have to do any additional monitoring. These are all self-imposed obligations we have on people that we've imposed on people. So the bare registration, I mean, we have millions of young men registered for the draft, doesn't cost us hardly anything other than just updating their addresses when they correct them. So registration doesn't have to be terribly expensive. But go ahead.
Well, this requirement ensures that the legislative intent, which is what we're concerned about, to focus on high-risk offenders, is upheld by necessitating a significant evidentiary showing of reoffense risk. The law prevents the arbitrary extension of registration periods for low-risk individuals. This aligns with the goal of freeing up resources to monitor those who pose a greater risk to public safety. So, the end thing is that law enforcement chases its tail a lot, trying to get everybody within its scope. In California, we've got well over 100,000 people on the registry. So the idea is to focus your resources and your time on those who pose the greatest risk, so that you can be accurate in getting the information out to the public of who's dangerous and who's not.
But then the argument also states that there is no evidence that community safety will be significantly enhanced by petitioners' continued registration. What are the mandatory considerations for determining this?
Well, the high bar for continued registration includes 7 considerations, and I'll name them off. 1, the nature and facts of the registrable offense. 2, the age and number of victims. 3, whether any victim was a stranger at the time of the offense. 4, criminal and relevant non-criminal behavior before and after conviction for the registrable offense. 5, the time period during which the person is not reoffended. 6, successful completion of CASOM, Certified Sex Offender Treatment Program. And 7, the person's current risk of sexual or violent reoffense based on risk assessment instruments. Now, so effectively, and I'm not discounting any of these factors, because they're all considered within the context of the hearing should you go there. But to effectively argue for removal in California, you must at minimum weave into your argument all the things we've previously discussed: the legislative intent behind the tiered registry law, and that a petition to terminate cannot be denied without significant evidence demonstrating a risk of reoffense, which includes, but is not limited to, the recitation of those factors in their most positive light.
All right. Well, what are the broader implications of this legal argument for the criminal justice system and public policy?
Glad you asked. I think the implications are substantial. If the courts uphold the need for significant evidence to deny termination petitions, it could lead to more efficient use of law enforcement resources and better protection of public safety, as I mentioned just a moment ago. But it also reflects a move towards evidence-based practices in the criminal justice system, ensuring that policies are driven driven by empirical data rather than blanket regulations. And that's real progress and hope for those who are ensnared in the process. And if we're on that trajectory, we're moving in the right direction, in my opinion.
Well, that's music to Andy's ears because he loves that empirical data.
Well, I do, but this also, I guess, help me with the terminology, Larry. But this puts the onus on the prosecution, the registry side, for them to come up with a reason for them to deny you, versus it being kind of like a rubber stamp denying. You have to provide an ample amount of evidence saying, no, I don't deserve to be on this anymore. It makes it harder for them to deny you this way, I think.
It does, and
you are correct.
That's the whole thing. I've always said if we're going to have a registry, I hate removal petitions. Well, California has a removal petition, but despite my protestations about it being a piece of crap, at least in the Thai case, the standard has been made clear that it's on the prosecution, which I can live with that as a compromise position because I'd rather there not to be a petition. People just time out. But since there is a petition, the fact that the government has to carry the burden, that is fantastic.
Now on the California side of things, Chance, I'm not directly asking you what does this cost, but if somebody comes to you and says, "Hey, I'm this kind of upstanding citizen. What do I need to do?" Do you charge them $50,000 million? Is it something that an average person can afford, or is it still like a heavy load?
Well, it's something an average person can afford. And the reason we break it down really to two parts, is because it's easier to fill out the petition on the individual side, even though, okay, sometimes there's a bit of confusion about how to exactly file it and do the other things necessary for it. But if it goes to hearing, you absolutely really need an attorney to do it. And so depending on the complexity of it and depending on, what needs to be done in comparison to what it costs, it's very, very, very reasonable in terms of being removed from the registry. The cost is minuscule.
Very good. All right. Is there anything else here? Did you want to dig into anything else, Larry?
No, I think that we learn more and more about California, and I'm having less anxiety about the system. I don't know how many people have gotten off. I don't know if that data can be retrieved. I was very doubtful that there'd be a significant decrease in the number of people on the registry. But apparently it is working, and it's working better than I expected. I still don't like the fact that people have to spend money, but I do like the fact that people they end up benefiting from the state having to bear the burden rather than them having to bear the burden. That is great.
Chance, somebody in chat has asked your hourly rate, and I'm telling you'd have to call.
Yeah, I don't charge hourly. I charge a flat rate, which is very reasonable. Because if I charged an hourly rate, it would be very unreasonable. So I don't even go there. I do charge hourly rates for other things I do, but for this particular thing, just to make it available for as many people as possible, I charge a flat fee. And also, I want everybody to understand this: if you can't afford to do it, can't afford to hire a private practitioner, you can always go to the public defender's office. Across the state, they're doing this too. So it's you have your choice, and for those who just can't afford it, it's still available to you through those institutions.
I want to make sure that before I go over that, what did you give me so California corner argument for removal? What do you want to tell people about this? Because I'm going to have it in the show notes for people to get it from FYP Education. But what is this PDF?
Yeah, that PDF is a section of a brief that I submit to the court. And it's a section of one of the briefs I've submitted to the court. It's a small section just so that we would get what's necessary to launch the rest of the argument. And so I just wanted to show people, demonstrate that there has to be a basis to leap from in order to accomplish this task if it's going to go to hearing. And so this is one of the things that I think is really important about representing somebody is filing a brief and making sure that you educate the judge as to all of this before the actual oral hearing begins. And that's just a small section of it that can be looked at.
Fantastic. Moving along, Larry?
Yes, I put this in here especially for you, and I know you're going to drive the bus, but I will do what little I know and do my best.
I have like a fundamental problem with these kinds of laws at the moment, but the Pennsylvania State Senate voted unanimously on Monday to criminalize naughty images of minors created with artificial intelligence. Senator Christine Tartaglione, yeah, go for that, said it is deeply troubling that we sit here today. AI is being exploited to create sexually explicit images and deepfakes involving minors.
And another sponsor said this misuse of technology is not theoretical, it's a reality. Around the country, schools have had to grapple with the proliferation of technology that has allowed students to create deepfaked images of their peers. You have a minor child. Can you explain to me and this audience, because what is deepfake images? I mean, I'm guessing you create naughty images that are not real, but what are we talking about here?
I'll give a different kind of example. There's a billboard, I think it's an attorney here in town, and I don't know what he looks like, but you can tell that he's like freaking on like some Mr. Universe competition kind of, and his face is superimposed over it, and it's blended pretty well. But there's no way that this dude is like some gym rat freaking benching and military pressing hundreds and hundreds and hundreds of pounds. That it would be kind of essentially what a deep fake is. So if you take a picture of an underage individual and you put them on a very, you have porn stars of all different kinds of ages and body sizes, and you put one that's very petite, 100 something pounds and 5'1" and get it all to blend, and you can have naughty images of kids. But it's not real. It's the same as what we would see. Do you remember the explosion during like one of the Iraq war kind of things where there was a building that had smoke coming out of it and it turned out to be a completely fake image? This was maybe 20 years ago.
Don't remember that.
Okay. Well, anywho, I mean, it's essentially that you're overlaying with Photoshop these days. There's AI built into Photoshop. You just say, give me a blah, 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 and the blah, 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 and the thing spins and you have an image that like, okay, this is ready for production.
Well, the article states numerous states have begun moving to address the issue with new laws. The bill passed by Pennsylvania Senate would work by clarifying that existing laws banning child pornography and the non-consensual sharing of pornographic images of sexual partners are still applicable when images are created with artificial intelligence. Quote, we need to do everything we can to prevent individuals from using AI for these insidious purposes, said the bill sponsor, Senator Tracy Pennyquick, chair of the Senate Communications and Technology Committee. By working in a bipartisan manner, the General Assembly is making it clear that Pennsylvania is not the place for this depraved activity, end of quote.
And I assume since it passed the Senate, what's next?
Well, the bill goes to the state house, where I don't see any reason why it wouldn't pass. And this is going to be a similar situation to Louisiana. If it passes unanimously in the House, I can't see any reason for a veto. So you got to kill it in the House, folks, if you don't want this to pass. And this is an uphill heavy lift because it's already passed one chamber unanimously.
How is this not? How does this not fit into a freedom of speech argument that you can mash up any two things that you want? This just happens to cross a line into a particularly subjective type of content. But how can you limit this from a free speech point of view?
Well, and therein lies something that will have to be resolved by the courts. But what we do know is that since possession of images of nude minors is that those are prohibited by law, that's not protected speech there. But if those images are of adults and they've been transposed, or what do you call it, photoshopped with a minor's face, and they're adult images, it gets very dicey. And I have no idea how this is going to resolve itself, but they'll have to pass it first. This is one of those things where we'll have to pass it, and we'll have to figure out if it's constitutional later.
Because technically, it's not an image of a minor.
Well, or is it?
I don't know how you would ever know.
Well, you take the minor's face and you impose it, and this is over my pay grade, but that is a minor. But the part that's the nudity is not. I don't know how this is going to play out.
Chance?
I just, it's such a freedom of expression issue. I mean, what if you don't do it with artificial intelligence? What if you just like take a canvas and paint it, or like a pencil and sketch it, or it's your imagination, and you're taking something from here and you're taking something from there. How is that not freedom of expression? I don't know.
That's what I'm getting at. 'Cause, I mean, you go to a fair of some kind. You go to like the Renaissance Festival, and they'll have like the people dressed in all the garb, and then there's the face cut out, and you go stick your face in it. Now your face is quote unquote superimposed over an artist drawing whatever of someone wearing like the Renaissance Festival garb. And I realize that we can all tell the difference there, but you keep extending that out to where you can really superimpose anything you want on anything. Most of us, Larry excluded, have watched all of the latest movies with the incredible CGI where they have people doing the most amazing things. Nobody did anything. The sets aren't real anymore. It's all done with blue screens and green screens. Like everything is fabricated now. And now we will include that we're going to get our naughty content that's all AI generated and superimposed over things.
It's interesting in this way. We're so involved in trying to prohibit real behavior that happens in reality. This is virtual behavior. And
Correct.
all of a sudden, we want to reach into the virtual world and start regulating there. I mean, don't we have just like enough laws to contend with already? It's crazy.
Obviously not.
All right.
Larry, get on that shit. Make this stop.
Well, I don't know anything about Pennsylvania legislative process, but I understand that state has a fantastic organization.
That's what I hear. All right. Well, then we will move over to this last thing because I didn't think we were going to get. We were not going to have enough content to fill out the hour, but here we are at 5 till. Back over in Chance's neck of the woods, California Democratic lawmakers pushed back Monday against Republican talking points about a handful of crime bills, saying the legislation targeting the retail theft crisis, not a proposed ballot initiative. Is this the best way to address this problem? Senate President Pro Temp Mike McGuire said Republicans have been spreading hogwash throughout the Capitol over the past few days about the crime bills. Assembly Speaker Robert Rivas said phrases like poison pill used by Republicans are propaganda and demonstrate their goal to play politics. There is no poison pills, Rivas said, adding moments later, these amendments are necessary. Chance, now's your chance to explain this.
Okay, I'll give it a shot. Yeah, Democrats at a Monday press conference said they intend to add an urgency clause to those bills, meaning they will become law immediately after being signed by the governor instead of becoming effective January 1st. The bills will have inoperability clauses added to them. If a proposed ballot measure passes in November and repeals Proposition 47, the crime bills would be voided.
Would you explain Proposition 47 then?
Yeah, it was passed about 10 years ago, and its purpose is to focus prison dollars on violent and serious offenses. Certain drug and theft charges were dropped to misdemeanors. Critics have said that the proposition emboldened thieves, pointing to videos on social media that show brazen thefts. Speaker Rivas referenced those videos, saying that he knew the action was needed when he took the Speaker's gavel last June. And he created a special retail theft committee to determine what change was needed and made a new appointment to his chamber's Public Safety Committee. The result was the package of bills Democrats hope to see passed over the next few months.
Assembly and state Senate Republican leaders last week issued a statement on the bill amendments. They oppose the additions to the bills, calling them an attempt to interfere in the state's initiative process. They claim that Democrats need to stop playing politics with public safety and... Oh my God, who just did that? Larry, you moved the lines on me. They claim that Democrats need to stop playing politics with public safety and let voters decide on fixing Prop 47, said Assembly member James Gallagher, his chamber's minority leader. These poison pills show that Democrats aren't serious about ending the crime wave. They just want to look like they're doing something because their years-long support for criminals has become a political liability.
In fact, Speaker Rivas said lawmakers added the inoperability clauses to the bills because they want to avoid potential legal conflicts. For example, one of the bills would impose a higher sentence on thieves who steal property valued at over $950. Repealing Proposition 47 would do the same, except it doesn't include an inflation adjustment. That just doesn't work together, Rivas added.
Well, all right. Larry, you had nothing to offer in this whole malarkey here?
Well, the only thing I have to offer is, since I don't understand that proposition, and I kind of understand the inoperability clause, meaning that the law they're passing will become inoperable if the Constitution Amendment passes. But the bottom line is, Chance, is this good public policy, yes or no? Because that's what I look at everything. I don't look at political parties. Is this good public policy for the state of California?
No. No.
So, I'm saying on which side of it is the Democrats, what they're trying to do, is that sound public policy, or the Republicans crying about what a disaster is? Who's right about this, in your opinion?
Well, I think they're both a little wrong in this. I think the whole idea should be rethought out. And I think that both sides should come together and make it better struggling with something that's not very effective, and just doing the, tug of war back and forth doesn't help the rest of the state. So yeah, they got to go back to the drawing board, is my opinion.
So, all right. Well, you'll keep us apprised, I'm sure.
Will do.
We are at that time limit, Larry. Are we gonna shut it down, or do you want to cover anything else real quick?
I just want to promote our next episode, which will be live from a major event.
It'll be packed, man. I mean, we could have actually like wall-to-wall people this time at the and doing the live recording.
Well, they were alternating breathing last time. How much more packed could it be?
Every third person only every third person will be able to breathe.
So,
well, be sure, if you do make it to Atlanta, come say hi, and we will be recording next Saturday night. God, it probably won't be until like close to 10 o'clock after the banquet and all that stuff. But we will certainly be recording a live session. You can bring food, snacks, booze, whatever you want to bring to the recording, and we can turn it into a super fun event. And maybe we'll even figure out how to chance in remotely. We'll have a telepresence chance, maybe.
You never know.
But yeah, so make sure that you show up. And like I said, if you want to bring any alcohol and turn it into a hoot and good time, because that's happened before. We've had like almost like a cheerleading section during the show. But all of that said, make sure you head over to Registry Matters for the show notes. That's registrymatters.co. 747-227-4477 is the phone number. Yes, Larry can stay up that late. It won't be past his bedtime. registrymatterscast@gmail.com for if you want to send an email. And as I said earlier in the show, go over to patreon.com/registrymatters. Oh, and before I forget, we did get a new patron this week, and that was Sprite, and you can contact her over on Narsal Connections. Like I said, patreon.com/registrymatters. And any final words there, Larry? Is it hot as hell out there?
not too bad. It's only 95.
Oh, 95. All right.
Only.
And I know, right? And Chance, I hope you have a fantastic, splendid weekend. Father's Day. Do you celebrate Father's Day tomorrow?
Oh, yeah. Thank you.
Okay, good. How many children do you have?
About 100. No, I'm just one. Just one.
Just one. All right, me too.
Just one.
Gonna go play video games with him tomorrow somewhere. It'll be great. And so, gentlemen, have a great night, and I will talk to you all in a week and see everybody at the conference. And if you're not there, up your patronage or go flog yourself. Those are your two choices. Have a great night, everybody.
Good night.
Good night.
You've been listening to FYP.